Is everyone connected?
Okay.
Very good.
We're good on our end. Looks like we're going to be able to screen share. So
very good. Ms. Crew, I think you're getting me to once again, following submissions from Ms. Evans, once again, we're staying away from formal characterizations from the common law and and staying away from equitable formulas or labels or characterizations.
that's right. And that goes back to what I won't repeat what I said yesterday. Instead, what I intend to go through with Your Honor today is the particular principles we say can be drawn from equitable compensation. And what I will be speaking to today is what those are and why we think they can apply in this case, even though we're not in the history of categorization of remedies flowing from the former courts of equity or common law.
Even though we are not in the historical categorization of, what does that mean? We don't meet?
I think that's right. We say it's not appropriate to go to common law. And there are various reasons for that. And I think it goes to what the Court of Appeal had to say in stage 1, and in particular at paragraphs 406 and 407. I won't pull those up, but really what the court's saying at that point is that common law is not particularly assistive to us because an Aboriginal treaty, as they put it, is not a contract. It's not subject to the rules of contract law. And it analogizing to contract law is not appropriate. So we say that the Court of Appeal was quite clear that common law rules and remedies, we say, therefore, shouldn't flow. Now, in equitable compensation, we know equity is a flexible doctrine that is capable of growth and development. That's true. But you would have to find a new, we say, category under equity in order to use it in this case. And I think, if I may, that's what the court was grappling with in the fiduciary duty consideration. It's like, well, if you don't have a fiduciary duty, can you go to equity? Because there's not an existing category to flow from.
Not an existing category in equity of treaty promises.
Exactly. And what we say is, instead of creating a new category in equity, what you do instead is you say, we're not going to try to force a sui generis situation, sui generis treaties, sui generis duties flowing from the honor of the crown. Why try to import that into equity when instead we say it should be possible, given the nature of treaty promises and what I went over yesterday, to say that you don't need to go there. You can say, what I'm doing is fulfilling the treaty promise. That's what the remedy is doing. That's the framework we're operating in. We shouldn't resort to common law because the court says that that's inappropriate. And we don't need to create a new category in equity.
You don't need to squeeze a circle into a square.
I was thinking of using that metaphor. So yes, I think that that's right.
But you're only saying what the courts have said, which is that treaty promises demand unique remedies.
Yes, they demand fulfillment, and they demand unique approach to interpretation and implementation.
Right, but I was talking about remedies. What my understanding is, courts say it's a sui generis promise.
Mm-hmm.
It attracts sui generis remedies.
Yes, remedies that are responsive.
Where the Crown is that then you go to equity, you look at equitable compensation, and you say, what can we draw from that? And the Crown says we can draw some, but not all.
Yes, that's
of
right.
The remedies that are available under the formal equitable remedies.
Yes. And what I want to speak to today on that point exactly is why we say some of the principles are helpful. And the headline for that is because some of those principles, they're directed at the same point. What would restore the plaintiffs to the position they would have been in had the Crown fulfilled its promises? And usually that's the fiduciary duty. In this case, it's not.
The same question. It's the same question for breach of fiduciary duty. Or are you saying?
It's certainly a very similar question. The duty is different. So, but it's going to the same question. How do we fulfill? How do we get to the point that would have existed in a non-breach world?
Go ahead.
So turning to those principles that we say apply. In our written submissions, we've listed those principles and they're separated by section headers for ease of reference. We've laid them out sort of 1, 2, 3. And my hope is that that assisted with readability and with clarity. But I want to emphasize today, and we say this in our submissions, that these are interconnected principles. But what I want to emphasize today is that they're not easily broken off from one another. They are deeply interconnected because at their core, they come back to the same point. And that is that compensation should respond to and flow from the breach. In equity, that might be a breach of fiduciary duty. In this case, the breach that we've discussed throughout the submissions of the treaty promise and the duty of diligent implementation. So we think about those principles of reasonable and realistic outcomes, compensating actual loss, realistic contingencies, what would have happened but for the breach. The through line in all of these is the directive that we're looking at what would have happened in a non-breach world in a realistic and principled way. And in terms of that assessment, we can draw from those principles. Now, we've cited a number of cases regarding these principles in our written submissions. Instead of going through each of those separately, I think it's helpful to look at one case, and that's Canson. And in particular, Justice McLaughlin, and that was when she was Justice McLaughlin before she was Chief Justice McLaughlin, her concurring reasons. There are 2 reasons that I think we can go down this road. The first is that Justice McLaughlin's reasons.
Can you direct me to either paragraph in the...
Yes, and I will be doing that. So,
or to your compendium.
Yes, the compendium tab is tab 2. I'll be starting on page 551 of that case.
Thank you.
The reason we say we can and should look at this case as crucial is twofold. The first is that these reasons by Justice McLaughlin are quoted and cited affirmatively in, I checked, and I think this is the case, all of the other cases we cite regarding equitable compensation principles. Guerin is the starting point, but this really is the foundation of the theory of how these principles work. It's a very clear articulation in that sense, and it's repeated over and over in the case law. And the second reason we say it's very helpful to look at this case in particular is because these reasons speak to the interconnectedness of the principles and how at their root, they all come back to the responsiveness to the breach and the obligations in issue. So as I said, if we start on page 551, which is up on the screen, Justice McLaughlin writes, "The Crown was required to compensate the band for the value of what was lost because of the breach, namely the opportunity to enter into a more favorable arrangement. The value of this lost opportunity was based not on the common law tort or contract measure of what might reasonably be foreseen at the time, but on the equitable approach of looking at what actually happened to values in later years." So in this quote, we see the principles of compensating the value of what was lost because of the breach, lost opportunity, and looking at what actually happened. We move down the page. Justice McLaughlin writes, "Just as restitution in specie is limited to the property under the trustee's control, so equitable compensation must be limited to loss flowing from the trustee's act in relation to the interest he undertook to protect." And now we're back to the principle we discussed yesterday. What is compensated is loss that results from the breach of the relevant duty. Over on the next page, that's page 552, and again, we're still at tab 2 of the compendium. Justice McLaughlin is summarizing and affirming the approach of the trial judge in Guerin and how that trial judge assessed loss caused by the breach. She writes, "He allowed for the time which would have been required for planning, tenders, and negotiation. And he also discounted for the fact that some of the then current value of the surrounding developments was due to the existence of the golf course. In other words," and this is the crucial sentence, "he assessed as best he could the value of the actual opportunity lost as a result of the breach." What we see here are realistic contingencies being used in order to ensure that what is being compensated is tied back to the actual opportunity that was lost as a result of the breach. Now we're going to move down a bit to page 555 of Canson, again, still in Compendium tab 2. And here Justice McLaughlin is comparing and contrasting equity and common law. And she says that the basis of compensation at equity, by contrast, is the restoration of the actual value of the thing lost through the breach. And then finally, the last portion I'll quote is at page...
Sorry, I just have to, when you start reading, I don't necessarily find it that quickly.
My apologies.
I think I've got it sidebarred on 555 at the top. Thank you.
Yes. And Ms. Zhang has also put it up on the screen if you ever want to refer to that quickly. It's highlighted there as well. So hopefully that can be of assistance. But if you ever, you can just say,
it's
pause.
Very helpful.
Yeah.
If it showed me the whole page, I'd know where to look. I only see it, the paragraph you're reading.
Okay, we can zoom out.
But I'm okay. We're doing it. We're doing it.
Okay. Try to make this as easy on everybody as possible.
I super appreciate that.
Okay. So as I said, the last portion I would like to quote from is on page 556 of Canson, and it's that second paragraph. Justice McLaughlin writes, by analogy with restitution, and that it is equitable compensation, it attempts to restore to the plaintiff what has been lost as a result of the breach, i.e., the plaintiff's lost opportunity. The plaintiff's actual loss as a consequence of the breach is to be assessed with the full benefit of hindsight. Foreseeability is not a concern in assessing compensation, but it is essential that the losses made good are only those which, on a common sense view of causation, were caused by the breach.
Thank you.
The point I'm making in pulling these sections up from Canson is that these principles drawn from equity have a role to play in this case because they provide guidance on the overarching question and issue. What fulfills the treaty promise and the Crown's duty, and what has been lost as a result? That's the flip side. What was lost because the Crown did not comply with its obligations? So with that, the final overarching question I have to address is what level of certainty, how sure should the court be as to what the non-breach world would have looked like, and whether any presumptions apply that affect this analysis? I'll start with the issue of whether any presumptions, either at common law or equity, apply in a way that affects the analysis. And I'll then discuss the level of likelihood that the jurisprudence directs. And the reason for this is if a presumption applies, then that's the answer. You don't have to be sure of anything. But we say that they don't, and I want to go through that. As I understand it, the plaintiffs have advanced arguments regarding both a common law presumption and two equitable presumptions that they say this court should consider to varying degrees to relieve them of their general burden to prove their losses. And I'll address each of those presumptions in turn. Starting with the common law presumption. The plaintiff's position, again, as I understand it, is that because the Crown did not engage with the plaintiffs in order to determine the amount of net Crown resource revenues to be distributed and whatever else a broad interpretation of engagement would require, which again, we don't agree that that's the duty. They say this court can presume that if this engagement had occurred, the pie would have increased in size. That is, that the court should presume that the breach of the engagement obligation resulted in some level of financial loss, perhaps beyond time value of money. And the plaintiffs submit, as I understand it, Mr. Schachter took you to this position. I believe Your Honor had questions about this, that they don't have to prove this assertion. And they have also admitted that there's no evidence supporting this assertion. They say that the presumption that this court can and should presume, even in the absence of evidence, that what they say is true.
How do you frame what the presumption is?
As I understand it, the common law presumption they advance, they say there's a common law presumption that where a defendant's wrongdoing results in a plaintiff not having information required to prove their loss, that evidence is not required, that they don't have a burden to prove their loss. Now, I will say I am cognizant that the plaintiffs submit they're not relying on this presumption. As I understand it, their position is that it's something that the court should take into consideration in determining whether their proposal in respect of resource rents and what would have happened with engagement, whether that submission is reasonable at large.
Thank you.
But we say irrespective of the way the plaintiffs say this asserted presumption factors into the court's analysis. To the extent that it has been put before the court, I want us to be clear about what the law says and what it does not say. Now, Canada, in its written reply submissions, set out the Supreme Court of Canada's decision in Rainbow Industrial Caterers and Canadian National Railway.
Sorry, at what paragraph, please?
That's at paragraph 19 of our reply submissions.
Thank you.
And the reason we did this is because that's the case the plaintiffs cited in their submissions, in addition to Wadham's on the law of damages.
Go ahead.
That's in our written submissions, reply submissions. I don't have more to add than what's written there. So instead of retreading that ground, and in the interest of time, I'd like to direct the court in addition to that to a decision by the Court of Appeal for Ontario that speaks directly to the existence of the presumption that the plaintiffs have advanced and rejects it. That case is at Compendium tab 17. The case's name is TicketNet Corp and Air Canada. Before I quote, because this is a case that hasn't been raised previously in the proceeding, I think it would be helpful to provide a brief summary just to situate us.
Go ahead.
So this is a breach of contract case by the Court of Appeal for Ontario, and leave to appeal was refused to the Supreme Court. It is a leading case on the extent of any common law presumption that arises where facts going to damages are unknown due to the defendant's breach. And this case concerned a business venture between TicketNet and Air Canada, in which those parties agreed to share in the future revenue of a software venture. On the eve of launching that software, Air Canada repudiated the contract, locked out TicketNet personnel, and obtained an injunction preventing TicketNet from bringing the software to market. TicketNet thereafter launched an action for damages, and the trial judge awarded it damages in excess of $11 million for loss of business opportunity to bring the software to market, so for future unrealized revenue. Air Canada appealed that decision, and they argued that the trial judge awarded damages by invoking a presumption in favor of TicketNet. That same presumption that the plaintiffs advance in this case. They said the trial judge improperly didn't require evidence. It assumed in favor of TicketNet. It invoked a presumption. The Court of Appeal held that the trial judge had not applied the presumption alleged, but also agreed that such a presumption was unsupported in law. So I'll start with paragraph 80, which is where the Court of Appeal discusses this point. And again, we're at Compendium tab 17, and this is paragraph 80. Says Air Canada submits the trial judge erred by invoking the rule of evidence expressed in the maxim, everything is presumed against the spoiler or wrongdoer, to assess TicketNet's damages. I've given everyone the benefit of me not trying to pronounce a rather lengthy Latin phrase in that one. The Court of Appeal continues, the trial judge began his discussion of damages by holding that even though the software had not been marketed, TicketNet still had the onus of proving its loss with the certainty reflected in the following passage of this court's judgment in Friedhoff and Palmolive Industries, Ltd. And then it quotes and affirms Friedhoff, says, with respect to the projected income and expenditure figures, while they're not capable of exact proof, the onus still rests on the plaintiff to satisfy the court on a balance of probabilities, taking into consideration all the factors going to make up such a projection, that the amounts included in such projection constitute a close approximation of what would have occurred during the period had the contract been performed. The Court of Appeal then quotes the trial judge at page 136 of the trial judgment. The trial judge said, it seems to me that projection of future profits should be prodded and poked in analyzing and testing them to ensure that the elements of reality, certainty, and non-speculation are present to a reasonably high degree. The Court of Appeal then summarizes Air Canada's various arguments. And if we go down to paragraph 85, it says, in my view, the maxim, that is the presumption, should only apply where the wrongdoer's act make it difficult or impossible for the innocent party to prove its loss, or where the facts needed to prove the loss are known solely by the wrongdoer and the wrongdoer does not disclose the facts to the innocent party. Now, I think this is what the plaintiff seized and extrapolated upon, particularly because this is sort of quotes back and forth between Wadhams. This quotes Wadhams and then Wadhams quotes this case saying, look, they quoted me. But what's important here is that that's not where the judgment stops. The court says there's this, the maxim could only apply in this case, but there's still limits on it. And it goes on at paragraph 87. And the Court of Appeal says, on my reading of the reasons of the trial judge, he did not depart from the basic test in Friedhoff. If he resorted to the maxim at all, he did so only in the limited sense of recognizing the obvious, that Air Canada's repudiation of the SDA, that's the contract, its lockout of TicketNet personnel, and its subsequent injunction prevented TicketNet from completing and marketing the software and therefore from proving its loss based on past performance in the marketplace. Because Air Canada's conduct prevented TicketNet from proving its losses using actual earnings, the trial judge recognized that TicketNet could rely on projections discounted to reflect realistic contingencies. Then it says, it's this approach that is consistent with Friedhoff and with the subsequent case law regarding valuing lost business opportunity. And what I say is that what's notable here is that that's how the parties have undertaken this case. In the face of not having actual values, we've all relied on projections, some of which might include discounts to reflect realistic contingencies.
When you start this particular section of your argument, when you say that's how we've approached this case, what part are you talking about? The bring forward?
The bring forward. But I'd say even the nominal values part, where there's some level of...
Because when we get to nominal values, I might need a bit more explanation on the tie-in, but go ahead. I just wanted to clear what you were saying.
I would say predominantly bring forward.
So you say the Crown has used a bring forward approach that follows this reasoning.
Not that follows this reasoning. It's common law. We're not resorting to common law. I'm just remarking that the plaintiffs have invoked this common law presumption. They say it says one thing. We say it doesn't say that. And actually what it does say is how the parties have operated. I'm certainly not saying that we're in common law.
Going back to your statement, which is I say that what's notable here is that's how the parties have undertaken this case in the face of not having actual values.
Yes, I was remarking that, again, there's a parallel that we see here. I'm not suggesting that we are in common law, because I'm very cognizant that this is a common law case. This is about a breach of contract and lost business opportunity. But what I am saying is that if the plaintiffs take the position that the portions of their argument that they say they don't have to support in evidence, that is, and again, this point from them, I would say, is not particularly clear how they say this presumption can or should operate. But I think they say it goes to the question of engagement and the presumption that the pie would have been bigger. Yes. So my point here is that if their position is that they don't have to lead evidence to that effect because of a common law presumption, that's inconsistent with the case law. But what the case law would support is what the parties have actually done.
Okay, so let me tell you where I'm not following the dots. You have just said that the plaintiffs rely on this presumption when they assert that they don't have to prove how big the pie would have been or how the pie would have been bigger had the Crowns diligently engaged as per their duty.
Yes.
Okay. Then you say, is the parties have undertaken this, I'm not sure what that is, in the face of not having actual values. We've all relied on projections.
I think the problem here is I'm not speaking to the engagement point, and I'm not suggesting that the court should rely on this case to say that what the parties have done is appropriate or what have you. I'm just saying that this is as far as the law goes. It only helps the plaintiffs, if we use this case at all, to say that the approach that the parties have taken with respect to bring forward, for example, is appropriate. But it doesn't go further than that. It helps the plaintiffs or any party. It just supports how the parties have undertaken this case. It doesn't relieve any burden to prove or lead evidence regarding an assertion. My final point on the common law presumption is that, to be very clear, there is no common law presumption that in the face of uncertainty, even uncertainty resulting from a defendant's breach, that unsupported speculation must be accepted as fact.
I'm going to feed that back to you, see if I understand what you're saying. All right. If I understand you correctly, you're saying there is no common law presumption that in the face, you use the word uncertainty, but in the face of an inability to prove that the pie would have been bigger, and even if that inability to prove that the pie would have been bigger is resulting from the Crown's non-disclosure or non-engagement, that the assertion that the pie would have been bigger should be accepted as fact.
Yes, you still need evidence.
Okay, just do I have that?
Yes, that's right. The only thing I would add is if you want to make that assertion, the plaintiff certainly could make that assertion, but they would need to lead evidence. And if we go by this case, they would need to take evidence that had the elements of reality, certainty, and non-speculation being present to a reasonably high degree.
Thank you.
Moving on to the equitable presumptions, the first one I'll deal with is very brief, and that's the so-called Brickenden rule. Again, I don't believe the plaintiffs say that they're relying on this presumption. Like the common law presumption, they say that I believe they say it may go to the engagement and what the pie would have looked like, or that the resource rents approach should be considered more reasonable because they aren't relying on this presumption. But as before, even if they're not relying on it or say that the court should just consider it, I want to be sure that we're all clear about what the law says on this point. The Brickenden rule arises from a 1934 decision of the Judicial Committee of the Privy Council. I don't have it in my compendium because I believe we can deal with this quite briefly, but if Your Honor would like a copy of that case, we can have one printed for you. But really, this is a narrow presumption that applies to mandatory pre-transaction disclosure, where the transaction is between a fiduciary and a beneficiary. When we usually see this is a lawyer entering a contract with their client. When that disclosure has not happened, that when that pre-transaction disclosure did not happen, the presumption shifts the onus to the defendant, the fiduciary, to prove that the plaintiff beneficiary would have proceeded with the transaction despite the non-disclosure. Because it's that narrow and that specific, because we're dealing with pre-transactional disclosure, we say that the presumption is not relevant in this case. It's not being relied on in a pre-transactional sense, as I understand it, by the plaintiffs. This is, for using the transactional sense, the transaction, I suppose, would be entering into the treaty. And again, it's between a fiduciary and a beneficiary, so that's another reason we say it doesn't apply. The final presumption that the plaintiffs rely on is the equitable presumption of most favorable use. Sometimes we'll hear this referred to as a presumption of highest and best use. And this presumption, I believe the plaintiffs do rely on, and it underpins the effective engagement on captured rents, the 60-40 bring forward approach, and perhaps to some extent the use of resource rents as a model in general.
Underpins the effective engagement on captured rents. What does that mean?
So the plaintiffs argue that, as I understand it, the plaintiffs argue that if Canada had engaged, or sorry, if the Crown, so Canada and Ontario, and if it was pre-Confederation, Imperial Crown, et cetera, had engaged with the plaintiffs, more resource rents would have been captured, or alternatively, if they had not been captured, Canada would have known that the First Nations wanted more to be captured and perhaps would have given more, even in the face of additional resource rents not being captured.
And then you add, and the 60-40 approach?
Yes, the idea that you take the most favorable use, highest and best use. I believe their position is the highest and best use for the annuities would have been to put them in a 60-40 portfolio mix and bring forward at that rate.
Am I wrong to recall that the plaintiffs said we're not relying on the presumption of most favorable or highest and best use? You may conclude that they are, but do I misrecall that?
My recollection was that they said they don't rely on Brickenden and common law, but I believe their submission is you should presume most favorable use. Or they took issue with Canada certainly saying that it should not apply. So our position is there are three reasons why this presumption of most favorable use does not assist the plaintiffs in this case. The first reason is that the presumption arises because of the existence of a fiduciary duty, and in particular, the fiduciary's obligation to act exclusively in the best interest of the beneficiary. Now, in that paradigm, the rationale for a presumption of most favorable use is logical. It flows entirely from the breach and what the fiduciary would have been expected to do in a non-breach world. If a fiduciary has to act in the best interest of the beneficiary, compensation is based on a world in which the fiduciary fulfilled that obligation. And because of the nature of the duty, the best use was mandatory. It flows from what the fiduciary would have and should have done in the best, in the non-breach world. So that's the first reason. The just general, we say it doesn't apply.
Because of the particular obligations arising in the circumstances of a fiduciary duty.
That's correct. But my second point is that even if Your Honor accepts that the presumption of most favorable use does have a role to play in this case, there's still an important limit on its application. And that is that the presumption must be realistic. And it has to remain focused on choices that were available in the non-breach world. That point comes from paragraphs 80 and 122 of Southwind. I won't quote those, but again, that's in the compendium tab 16, paragraphs 80 and 122 of Southwind. And the points there are that the presumption has to be realistic and focus on choices available in the non-breach world.
So the debate on this point is that the plaintiffs say it's a realistic choice because there is evidence that another band in Ontario was active in the market as early as, I can't remember, 1850 or 1860, and that there is further evidence in this case that in other decades, I also don't recall which ones, Bishop Picotin was active in the market and reached out to financial advisors. And you may say that is very limited evidence, but I don't recall that there was evidence to contradict it.
I believe there was evidence led to contradict it. And I know Ms. Evans is intending to speak to that evidence. I'll admit I'm less familiar with that evidence than she is. So with Your Honor's permission, I might defer that question to Ms. Evans.
All right. But you say there is evidence to contradict that.
Yes.
Is that from Mr. Angel?
I believe it's from Ms. Evans has just requested that I just defer the question to her. She has it in her submissions to speak to directly. So.
Okay.
So with that,
there was a moment when I thought we should have hot tubbed the witnesses on the stand. Now I think we should hot tub the lawyers.
Would you prefer to hear from Ms. Evans on this point right now? We're in your hands on what's helpful.
Please go ahead.
Okay. So we say there's a good example of how the limit of realistic and available choices could play out in practice. And that's in Justice Laskin's decision in Whitefish. And that's at tab 19 of the compendium and paragraph 82.
I'm just going to go there.
Mm-hmm. So Justice Laskin says, at paragraph 82, Whitefish also argues this scenario is consistent with equity's presumption that the proceeds of sale of Whitefish's timber rights would have been invested in the most profitable way or put to the most advantageous use. This presumption, however, does not come into play because we know what the Crown would have done with the fair value of these rights. It would have invested 90% in the trust account it maintained for the band and distributed the rest to the band members. And Justice Laskin says the reason we know this is because of the law at the time and past Crown practice. The third point I would make in respect of why we say this presumption should not apply, or at the very least is quite limited, is that we're working in a treaty case.
Sorry, have you finished on this point?
On
paragraph 82?
Yes, that's correct. If you have, I'm certainly happy to answer questions you might have arising from that.
So the evidence comes from the Crown that by law and by practice, they would have done something.
Yes.
And what does that have to do with evidence led by the plaintiffs?
In Whitefish or in this case? It's a question of evidence.
Yes.
So in any question of evidence, the court, as the trier of fact, weighs the evidence. If it's conflicting evidence, it considers which evidence it might prefer, but it is focused still in looking at that evidence on the direction that the presumption of most favorable use must be realistic and remain focused on choices that were available in the non-breach world. The last point I'd make on the equitable presumption of most favorable use is a simple one, and that's that we don't agree that the presumption can or should operate to contradict or override the treaty promise itself or the nature of the Crown's duties to diligently implement the treaty promise. The last section I have to address is that level of certainty point. I don't know if now might be a good time for a morning break. We're a little bit early, but.
It's okay. I have two questions, if you don't mind.
Of course.
On your last point, the presumption can or we don't agree that presumption can or should operate to contradict the treaty promise. And what are you saying here?
So what we're saying here, for example, is particularly on the engagement point. If the presumption is being invoked in respect of what engagement would have resulted in, we have to remain focused on the nature of the promise and the duty to diligently implement it, and what this court and the Court of Appeal found on stage 1 regarding the extent of that duty, particularly with respect to engagement. So the application of a presumption shouldn't override that.
And what do you say the plaintiffs are presuming that is contradicting the actual promise?
So in particular, with respect to engagement, our position is that the plaintiffs are reading the duty to diligently implement the treaty, which includes that engagement requirement. They say that that's a treaty promise, which we say is not correct. We say it flows from the duty to diligently implement the treaty promise. And they are also expanding the nature of that engagement to have a say in how the Crown captures resources as opposed to sharing information regarding resource rents or net Crown resource revenues. And the presumption, they say, is that if you presume highest and best or most favorable use, the Crown would have engaged in a way that was most favorable to the plaintiffs, would have maximized capture or sharing at the very least.
Do you say anything that the plaintiff presumes contradicts or overrides the treaty promise?
Yes, I think so, because that's, yes, to be clear, we say that they are.
Okay, how do they contradict or override?
We say that the presumption of maximizing that capture or engagement is contrary. First of all, they say it's a treaty promise. We say it's not. But also by saying that there's a maximization requirement, we say that that is contradictory to the requirement that increased annuities are required from time to time based on net Crown resource revenues, where the increase could be made without the Crown incurring loss. And that's the crucial way that there's a contradiction there.
Okay. And my second question, you say the 60-40 approach is the best and highest use. I thought we heard evidence from at least Professor Stiglitz, maybe another economist, that the best and highest use might have been 100% in equities.
Well, 2 points to make on that front. Canada is not submitting that the best and highest use was 60-40%. That's the plaintiff's argument. Ms. Evans will make submissions on why we say that the level of risk inherent and other considerations are not consistent with a finding that 60-40 even is the best and highest use, but that's the plaintiff's position, certainly. And then the second point to make on that front, sorry, if you could go back to the question. I just want to make sure that I'm answering it effectively.
Well, I thought it was your submission that the plaintiffs were relying on a presumption of best and highest use as a requirement.
Yes.
And I thought from that you said that they put forward, and you concluded that from their proposal that the court adopt a 60-40 approach. And you say that is the best and highest use. And that, therefore, the plaintiffs are relying on best and highest use. And that was your answer when I said, I thought the plaintiffs said they weren't relying on best and highest use. And the reason I thought they said that, I'm happy to be corrected if I'm wrong, is that they led evidence that the best and highest use might be 100% investment in equities, so that they weren't relying on best and highest use in any event. And then I also thought that they said they weren't relying on that presumption.
Well, I will say, if I misspoke, I certainly did not intend to convey that Canada's view was that 60-40 was the best and highest use. So I'll clarify that. With respect to the plaintiff's position, I do believe they're relying on most favorable or best and highest use to support 60-40. Now, whether or not they say there might be an even better or higher use for 100%. I don't think they've taken that position in their submissions here. There may have indeed been evidence to that effect, but I believe their position here is that the presumption supports the 60-40 approach. Canada disagrees for a number of reasons, but we understand that the plaintiffs are relying on the presumption to support a 60-40 approach.
Thank you.
Thank you. Given that it's 11:14 and I'm about to start a new section.
We'll take the break. Thank you. 15 minutes, and I will stay here.
Order, all rise.
I need help.
This court is to down for 15 minutes.
Order, all rise.
Court is resumed. Please be seated.
Go ahead.
Thank you. The final point I want to address is the last question I outlined for Your Honor yesterday, which is what level of certainty should the court have about what would have happened if the Crown had fulfilled the treaty promise and its duty of diligent implementation.
Is that also, what level of certainty should the court have about the non-breach world?
Exactly. And I think this is what Your Honor was speaking to when you asked Ms. Evans on Friday about what realistic outcomes means. I'm hoping that in going...
You said you would answer all my questions.
Well, if I get to the end of this and I haven't, I'll just stay in this chair. We can continue. But as I said, what I'm hoping is that in going through the relevant case law on this point, we can answer that question and any others that Your Honor may have.
Okay.
So when I look at the various submissions and the jurisprudence, I see that there are really 4 levels of what I'm calling certainty, or, how sure do you have to be referenced therein. The first level is what absolutely or almost absolutely would have happened in a non-breach world. This is often referred to as mathematical precision. The second is what realistically and reasonably was likely to have happened in a non-breach world based on available evidence. The third is what the plaintiffs have described as the could have standard, or what they say is what was not impossible in the non-breach world. And the fourth is what was unlikely or could not have happened in the non-breach world. The first level, I think we can dispose of quickly, and that's certainty or close to it. That standard has been expressly rejected in the jurisprudence. So, for example, and I won't pull this up, but I think it's reasonably uncontroversial. In Cadbury-Schweppes, for example, at paragraph 99, the Supreme Court expressly rejected this standard when it said that mathematical exactitude is neither required nor obtainable. The second level is what we say is what realistically and reasonably was likely to have happened in a non-breach world based on available evidence. This is the standard that we see supported in the jurisprudence. The directive we see in the jurisprudence is that the court should determine what was realistically and reasonably likely to have happened if the Crown had diligently implemented its duty. In this case, the treaty promise and the duty of diligently implementing it and making that assessment on the basis of evidence. Now, that standard appears repeatedly throughout the case law.
So I'm just short forming for myself. Crown had two obligations, as you have said from the beginning, and we can call one the promise, the treaty promise, and one the obligate and one the duty flowing from the honor of the Crown. Mm-hmm. And so you say, when you're looking at the non-breach world, it's fulfilled its promise, fulfilled its duty.
Yes, that's correct.
Okay.
And what standard is required in order to say how sure do you have to be what that non-breach world looked like, where the Crown fulfilled the promise and its duty to diligently implement that promise? That's seen throughout the jurisprudence, but I'll just refer to a few cases that I think are particularly illustrative and provide some helpful guidance on how that assessment works. So if I can ask the court to turn to tab 16 of our compendium. And again, that's Southwind. And we're at paragraph 74. The court here is quoting from Justice McLaughlin in Canson. We keep coming back to that. It says the plaintiff's actual loss as a consequence of the breach is to be assessed with the full benefit of hindsight. And it talks about foreseeability and says that it is essential that the losses made good are only those which, on a common sense view of causation, were caused by the breach. That's the starting point. Then if we go to paragraph 123 of Southwind, again, we're still at compendium tab 16.
Yes.
Paragraph 123, the court says, it's unlikely that the trial judge could recreate with mathematical precision what would have happened nearly a century ago had Canada fulfilled its duty. Instead, a trial judge will often have to provide a global assessment of the lost opportunity, and that assessment needs to be realistic. This will often require the trial judge assess various hypotheticals or proxies for that value.
Go ahead.
And then if we move to paragraph 132, this is sort of in the middle of that paragraph, the sentence that I'm going to direct your honor to, but I think the paragraph itself is quite helpful. But the sentence starts, the fiduciary obligation. Ms. Tsang has that highlighted on the screen if you want to see exactly where we're at. The court says the fiduciary obligation must always be defined first, and then the trial judge assesses reasonable or realistic outcomes in light of those obligations. The next case I would like to direct the court to is Cadbury-Schweppes, and that's at Compendium tab 1. And paragraph 73. And we're going to look at that second sentence in paragraph 73, where Justice Binney, who's writing for a majority of the Supreme Courts, directs that courts are free to draw inferences from evidence as to what would likely have happened but for the breach. The next case to look at, we say...
What's likely? Is that your third level? No.
What would likely have happened? This is the second level, realistic and reasonable. Okay. And what's realistic and reasonable is what would likely have happened based on available evidence. The next level is what could have happened or what was not impossible. But we're still in this. What I'm showing here is that this is really woven through the jurisprudence, this idea of realistic, reasonable, based on evidence, actual loss. In Guerin, Justice Wilson summarized and affirmed the trial judge's approach. And I think it's helpful because it shows how this shapes out in practice. It talks about what role the evidence plays. And so Guerin is at tab 3 of our compendium, page 358. It's down at the bottom. And it's a long passage because Justice Wilson, she's summarizing what the trial judge did. And she goes on to say, this is the proper approach. And so it's a bit lengthy, but I think it is helpful. And she writes, the trial judge therefore moved to other potential uses, that's of land, and concluded on the evidence that the 162 acres would at some point of time have been successfully marketed as prepaid 99-year leasehold lots for residential development. He found, however, that such development would not have got underway for some years following the date of the golf club lease. Time would have been required for planning, for tenders, for negotiation. Moreover, development might have been slow at first. However, based on the evidence before him as to economic, business, and population trends, real estate values, housing accommodation demand, and raw land shortages over the period 1958 to 1973, he concluded the area would probably have been well on the way to full development on a residential leasehold basis by 1968 to 1971. He noted in passing that this type of development had taken place on other parts of the reserve, and he made due allowances for the fact that those developments were probably assisted by the presence of the golf course. And then if we scroll down slightly at the next paragraph and the sentence that starts, he acknowledged, Justice Wilson writes, he acknowledged that this figure could not be mathematically documented, but stated at page 441 that it was a considered reaction based on the evidence, the opinions, the arguments, and in the end, my conclusions of fact. What we see here is an emphasis on the use of evidence and how that assists a court in determining what likely would have happened in a non-breach world in order to reach a realistic and reasonable outcome. That brings me to the third level we see proposed. That what you look at is what could have happened or what was not impossible in the non-breach world. We say that's not the appropriate standard. Before I get into that, I do want to acknowledge that the words could have are used in Southwind. But read in context, I submit that those words don't indicate a separate lower standard of not impossible. So if I'll pull that up so you can see where I'm getting that context from. We're going back to Southwind again, Compendium tab 16, paragraph 122.
Go ahead.
So we start with here, Canada should have negotiated compensation for the LSFN on the best possible price, which in this case was the value of the land to the project without the limitations of expropriation law. So again, we're looking at a non-breach world. Equity can presume that the LSFN would have consented to a negotiated settlement at the best price the Crown could have realistically obtained at the time. So that's where we see could have. But the trial judge must determine what the highest value of the land to the project realistically was in 1929. As I will explain below, the value of the compensation that Canada should have negotiated for the LSFN is not determined based on an evidentiary presumption It's based on evidence that was available to the trial judge, such as comparable agreements with another First Nation. So I would submit that when the court uses the words could have, they don't mean not impossible. They're saying if the Crown, complying with its fiduciary duty and its obligation to act in the exclusive best interest of the First Nation, well, it should have found the best possible contract that it could have realistically obtained. And you determine that based on evidence. And they said, such as comparable agreements with another First Nation. In my submission, that sounds a lot more like the second standard we were just looking at. We also need to be cognizant that actual loss is a phrase repeated again and again in Southwind. I think the Supreme Court in Southwind's conclusory statements summarize this point well. So this is at paragraph 175, and I noted last night that that's not included in the paper copy, so I apologize for that. It is in the electronic copy up on the screen, so you have my apologies on that front. But at paragraph 175, the Supreme Court affirms and provides deference to the trial judge's findings because they say they are in respect of what would have actually happened in 1929 had Canada not breached its duty, and because they were based entirely on the evidence before him, including a lengthy historical record and numerous expert reports.
Thank you.
And so fourth, we get to the unlikely standard. Would not have, could not have happened. We do actually see this standard used, but it's in the inverse. It's the flip side. Where a court finds that an event was unlikely to happen, they say it's not a proper basis for compensation assessment, or they impose a realistic contingency. And so I think Guerin is another good example because it provides us with such a practical implication of how that actually works. So if we can go back to page 358 in Guerin, and that's at Compendium tab 3. And it's the paragraph that starts, the second to last paragraph on 358 that starts in other words. It says, in other words, just as he had found that the lease the band wanted would not have been entered into, and therefore the value of that lease could not be used in assessing the band's damages, he likewise found that no golf club lease would have been entered into, presumably on the basis that the so-called, quote, fair lease could not have been obtained. the value of the land in 1957 and 1958, and its increase in value subsequently made the use of a golf course uneconomic. What we see, and then it continues with what we looked at earlier of what would have happened. So the trial judge contrasts what would not have happened and what would have realistically, based on evidence, likely have happened. And combining these, we see how that second standard and the fourth standard operate together. What, based on evidence, was likely to have happened and what, based on evidence, was unlikely to have happened, both inform the assessment, but in different ways. Subject to any further questions, those are my submissions.
Thank you very much. Thank you.
We could just take a moment. I'll raise this back up and I'll switch places with Miss Evans.
Good morning, Justice Hennessy.
Good morning.
Following our outline of submissions, the next topic is net Crown resource revenues versus economic rents. And I'm going to go through our overarching argument that this court should be looking at net Crown resource revenues rather than economic rents, and I'll explain why economic rents are inappropriate. And at the second part of that submission will be on spectrum in particular, which my colleague, Ms. McNamara will get to. I think that will probably take us to the end of the day. And then tomorrow I'll address present value and the other topics laid out in our outline. But first, before diving into the net Crown resource revenues issue, I just wanted to follow up and answer a question that you asked of my colleague, Ms. Crew, when we were talking about the TicketNet case. And Ms. Crew had explained in TicketNet that because of Air Canada's repudiation of the contract, which prevented TicketNet from proving its loss using actual earnings, the trial judge recognized that TicketNet could rely on projections discounted to reflect contingencies. That's a quote from the Court of Appeal and TicketNet. And Ms. Crew told you that what is notable is that this is exactly how all of the parties in this case have undertaken the task. In the face of not having actual values, they have relied on projections, some of which might be discounted to reflect realistic contingencies. And your question was, are you talking about the present value analysis? And I think probably because when we use the term realistic contingencies, when we have used that in our written submissions, we're talking, if not exclusively, at least usually about the present value analysis. But as Ms. Crew explained, we're also using projections in the assessment of nominal values, net Crown resource revenues, and economic rents. We talk about net Crown resource revenues in some degree as though they're actual revenues, but even that we need to take in mind that even those so-called actual revenues are actually in most cases based on projections. For example, we've seen that both sets of experts, from the plaintiffs and Ontario will take province-wide figures, for example, and make assumptions and projections about what that would have meant for the Robinson Superior Territory. And another example is the plaintiffs, for example, take expense ratios pre-1945 and project what they might be post-1945. So in this case, in that sense, all of the parties are relying on projections. You also asked Ms. Crew about evidence for the present value analysis. And I'm going to address the present value analysis probably not until tomorrow, but just very briefly, I will acknowledge that you need to work with what the available evidence is in determining what reasonably and realistically was likely to have happened in the non-breach world. You need to base that on the available evidence. And it is true, as you noted, Justice Hennessy, that part of that evidence was what did Six Nations do and what did Michipicoten do? And I will, when I get into that argument, explain why that evidence was very limited and really not helpful. But there was also evidence provided by what we've called the lay witnesses, the elders and chiefs, about the Anishinaabe practice of principle of providing for 7 generations. I acknowledge that's part of the evidence. There's also evidence before you in the reports and testimony of Dr. Angel and Dr. Booth about how money was actually managed by the Crown on behalf of First Nations since 1860, and how there were no powers of management by First Nations over the funds until 1951, and even then limited management.
You say evidence from Dr. Angel and Dr. Booth about how money was managed by the Crown on behalf of?
That's right. And of course, I know that, you know, part of the issue that we'll get into is if these increased annuities had been paid, would they have been managed by the Crown? But that's an issue we need to get into, and we will. But right now I'm acknowledging the kinds of evidence that you have on this point. And part of that evidence is Dr. Angel and Dr. Booth's evidence on what was available under the law at the time, what was historically actually available as options for investment. And the final category of evidence that you have on what would have happened in the non-breach world with respect to investment is the Booth-Kersner analysis on both habits of investors generally, such as risk aversion, and secondly, actual spending patterns of these bands, or at least a sample of half of these bands. So these are the categories of evidence that we will get into in more detail when we address present value, but I did want to respond to your question to Ms. Crew about what kind of evidence do we have aside from the limited evidence on Six Nations and Michipicoten.
On that point, before I forget, it's very helpful that you answer those questions. Thank you. I will be asking everyone what they understand the word sacred to mean. I'll just leave that with you. Not everyone, every party.
Are you asking me that? I'm sorry. Are you asking me that question, or are you asking?
No, I'm just putting you on notice before the end of your submissions.
Okay, because Ms. Crew did provide an answer, and I'm wondering if you want my individual answer.
Oh, no, not your individual answer.
Okay, thank you. So I think Ms. Crew's answer on behalf of Canada is Canada's answer.
Thank you.
So I want to start by discussing why net Crown resource revenues, which I might shorten to NCRR, an acronym we use throughout the trial, why NCRR and not economic rents. And I told you in my overview that there are 2 branches to my argument. The one is the first layer, which is that the parties and the court intended an NCRR. And the second branch of the argument is the problems with economic rents being impractical, and unreliable, not capable of measurement or collection. So going back to the principles that Ms. Crew went through, just to ground this in those principles, we heard from Ms. Crew that one of the important principles is that compensation should flow from the breach, which means that it flows from the obligations in issue. And here the obligation was in augmenting the annuities in order to share the proceeds of the lands. The obligation was not to capture all possible resource rents, including those that went to private owners and producers. And we know this because, first of all, the Court of Appeal was very clear in explaining that that would require a fiduciary obligation, which doesn't exist here. And the second reason we know that the obligation was not to capture all possible resource rents, including those collected by private owners and producers, is because that would be unrealistic. The experts for Canada and Ontario told us that governments do not capture 100% of resource rents in the real world. There are problems with measurement and problems with collection. And this sort of follows the two layers of argument that I said I would get into. The first one being by the parties' agreement, the judgment, and the Court of Appeal make it clear that the appropriate measure is revenues collected by the Crown. So the first thing I want to look at is the judgment. And I want to start actually with the preamble. Through notices of motion. Item number 2. I'm just waiting for my colleague to get it up on the screen. This is the judgment at page 296 of the Ontario Court of Appeals decision.
In the compendium, did you say?
It's tab 15 of the compendium of authorities. The one that Ms. Crew was using is the judgment is there at tab 15.
Thank you. And you're taking me to the preamble?
I'm taking you to the preamble. And isn't it interesting that my copy doesn't look the exact same as what's on the screen? I'm looking to, if you just give me a moment. Through notices of motion for summary judgment, and then we get to paragraph 2, the plaintiffs acknowledge. Do you see where I am? Thank you. The plaintiffs acknowledge that in addressing this motion, the parties were permitted to address and seek determination of particular issues, including sub B, whether the revenues that are to be taken into account in determining whether, quote, the territory subject to the treaty produced or produces an amount which would enable it to do so without incurring loss, close quote, are restricted to Crown revenues from the territory. And then we see, after that preamble on the next page, on being advised by counsel for the parties, near the outset, of the summary judgment trial that there was no dispute regarding issues 2B and C noted above, and that in relation to those issues, the parties were in agreement that the revenues that are to be taken into account, et cetera, are to be net Crown revenues from the territory. And the point here being, Justice Hennessy, the parties agreed, and then the judgment therefore provides on the parties' agreement that revenues to be taken into account are restricted to Crown revenues from the territory. This means revenues collected by the Crown, not rents that may have gone to third-party private producers and manufacturers or owners. In contrast, the figure of $126 billion proposed by the plaintiffs includes all of the alleged rents, most of which would have gone to other parties and not the Crown. Now, my friends have raised the argument that the Crown indirectly captures some of those rents through taxes, indirect taxes, 30%, my friends suggest. And I will address that argument later. I just want to acknowledge that it's there. But looking back at that preambular clause in the judgment on being advised that the parties agreed that we're looking at Crown revenues and net Crown revenues from the territory, I submit that everyone understood, as everyone would, that we were talking about money actually collected in the form of direct levies and taxes, direct fees relating to the resources. Now, I would point out as well that the phrase net Crown resource revenues is used repeatedly throughout the judgment. For example, we've been through some of this already. It's obvious, it's repeated. It starts in paragraph 1A. The Crown is obligated to increase, and the First Nation treaty parties have a collective treaty right to have increased from time to time the promised annuity payment of £500 if net Crown resource-based revenues from the treaty territory permit. So this phrase net Crown resource revenues is used in paragraph 1 sub A.
Just looking for the 1A that you...
This is the operative part of the order. This court adjudges and declares that.
Oh, here it is. Thank you.
So we see it in 1A, net Crown resource revenues. We see it in 1B. In the 1B, number 1, there's sub I. And then sub 2, we see Crown resource-based revenues without the word net. We see it in paragraphs 3A, the process adopted for purposes of determining the amount of net Crown resource-based revenues. We see it in 3B a couple of times. Net Crown resource-based revenues appears in B itself, and then again, Crown resource-based revenues appears in sub I. And then we see it again in 3C. And I submit that the parties understood that what was being referred to were revenues actually captured by the Crown. Now, I want to move on to how the Court of Appeal dealt with this, how the Court of Appeal understood it. And I have 2 points to make here. The first is that the Court of Appeal expressly removed the concept of, quote, value of the resources, close quote, from the judgment where it had appeared. They amended paragraph 1D. So I'd like to take a look at that, paragraph 1D. The Crown must diligently implement the augmentation promise. And you'll see there that the Court of Appeal removed the part of the phrase that had been there that referred to so as to achieve the treaty purpose of reflecting in the annuities a fair share of the value of the resources. The Court of Appeal noted the ambiguity in the word value and how it was used in the stage 1 decision. I'd like to take you to Ontario Court of Appeals, paragraph 293. And I would argue, Justice Hennessy, that the phrase, the value of the resources.
I'm just putting my hands on it.
293.
Thank you.
I'll go through that first. My colleague has it on the screen. From the Anishinaabe perspective, the principles that the trial judge found fundamental to the Anishinaabes' understanding of relationships, particularly the principle of reciprocity, suggests that the treaties would have been viewed as an agreement to share in the value of the territory. But the word value is notoriously vague, as a review of the evidence shows. The phrase, I submit, Justice Hennessy, that the phrase, the value of the resources, as it was used in the judgment at paragraph 1D, connotes something potentially broader than the revenues actually collected by the Crown. And in removing the words value of the resources, in my submission, the Court of Appeal explains that, first of all, the term value is ambiguous, but here it was used and should refer to the revenue produced from mining and sales of lots and such. And so I want to take you to paragraph 2. First of all, I want to take you to paragraph 293, which I did. But while I was there, I noticed as well, if we take a look at paragraph 290, I'm just going to jump back for a moment. When we talked about the crown allocation, and Justice Hennessy, you asked me about how do we know that future increases in the annuities will be funded out of the actual revenues? I said this was an argument that Canada has made for over 100 years. But we see here actually the Court of Appeal in paragraph 290 saying, at the most obvious level, the concept of sharing was built into the augmentation clause. Any future increase in the annuities will be funded out of net Crown revenues, revenues from the ceded lands in excess of costs. In that simple sense, the revenues would literally be shared. So back to my point about value, I want to take a look at paragraph 301.
Sorry, what did you say? You said in removing the quote value of resources, the Ontario Court of Appeal was saying what?
In my submission, that value of the resources potentially connotes something broader than actual Crown collected revenues. And in my submission, the removal of that phrase was intended by the Court of Appeal to acknowledge that, no, we're not talking about the value of the resources generally, we're talking about the actual collected revenues. That's my submission, Justice Hennessy. So I wanted to look at paragraph 301. And here, have we got it?
Okay.
So this follows from the Court of Appeals comments. Here we have Justices Lowers and Pardue writing for the majority, effectively. Paragraph 300 notes that the word value is used in different ways in the evidence and by the trial judge in her reasons. And Justices Lowers and Pardue go on in paragraph 301 to say, it is clear that a monetary conception of value was being employed, here they mean by the treaty negotiators, and that the value in question related to revenue produced from activities in the territory, both revenue from mining locations and proceeds from sale of lots. I submit that this reflects the Court of Appeals understanding that, and of course, this judgment was made before, well before the exchange of expert reports in the case, that what they're getting at is net Crown resource revenues. And this is made most clear in Justice Horrican's decision when he rejects the existence of a fiduciary duty in these circumstances. And it's important to turn up that paragraph 606, which we've looked at before, but it's key, so I'd like to look at it again. So paragraph 606, Justice Horrigan says, he's talking about if there were a fiduciary duty found here, the beneficiaries in these cases could argue that they are entitled to the revenue generated and what revenue could have been generated by the lands covered by the treaties. For example, an argument might be advanced that the Crown set mining rates at too low a level in order to attract investment, create good-paying jobs, and generate tax revenue. Arguably, such policies prefer the interests of the Crown or those of third parties over the interests of the treaty beneficiaries. He goes on to say, if it were a fiduciary situation, the Crown would have the onus of establishing why its policies did not amount to a breach. In that regard, its arguments about its public policy motivations in setting its mining royalties would be of no moment. What he's really saying here is that the Crown does have public policy motivations in setting mining royalties. It might set mining rates at a low level in order to attract investment, create good-paying jobs, and generate tax revenue. It might create policies that might arguably prefer the interests of third parties over the interests of the treaty beneficiaries. In rejecting the fiduciary standard, the fiduciary duty standard, Justice Horrigan is telling us that all of this is acceptable. It's not in conflict with the duty of diligent treaty implementation to permit the Crown to make public policy decisions about how it will collect resource revenues. And I note in particular, he's referring directly to the setting of mining rates at too low a level. This is getting directly at and rejecting the argument that the treaty beneficiaries should be entitled to amounts that the Crown could have collected if the Crown had set mining royalty rates higher. This is what the Stiglitz theory of economic rents argues. that if the Crown had enacted better rent capture policies, such as higher mining royalties, then it could have collected more. The second component of this paragraph 606 to look at is the explicit reference to preferring the interests of the Crown or those of third parties over the treaty beneficiaries. Again, the Stiglitz theory of economic rents argues that the Crown improperly allowed third parties, like owners and manufacturers, to benefit from the rents the Crown should have captured. But the Ontario Court of Appeal is expressly rejecting this argument and communicating to us that the proper measure here is net Crown resource revenues actually realized, collected by the Crown, exercising its policy discretion about why it set rates at a certain level, for example, and about whose interests were ultimately advanced. Or I should say, to what degree various parties' interests were advanced. So in my submission, the concept of economic rents were not in the minds of the parties. That is reflected in the judgment itself, in the fact that the parties agreed that in assessing whether there were sufficient revenues to augment the annuities, we're talking about Crown revenues, not rents which were uncollected and that may have gone to other parties. It was also not in the minds of the judges of the Court of Appeal, for sure. And that...
I'm just going to ask you for a moment to catch up.
Sure.
Thank you.
I'll just finish this point. I was saying that economic rents were not in the minds of the parties, were not in the minds of the judges of the Court of Appeal, at least. Mm-hmm. And the parties and the judges are in good company because both of the Crown's sets of economic experts, all four of the Crown's economic experts, read the reasons and the judgment to refer to net Crown resource revenues. That's the way they read the reasons and the judgment. They analyzed it on the basis that what we're looking at is net Crown resource revenues. So their interpretation as expert economists was that what was meant here by this language is NCRR. And this made sense to them, not just because of the language used, but because they tell us that the theory of economic rents, if it were to apply in this context here, would be impractical and imperfect. Well, imperfect, which is what makes it impractical. So I see that it's 12:30. I'm happy to continue, or we can take a break now.
Okay. We'll take lunch then. Is 2 o'clock good?
That's fine.
Very good.
Order, all right.
Till 2.
This court is stood down until 2 p.m.